69.
My lord, I beg to appear for the petitioner.
ಯಾವ್ದು ನೆನೆದ?
Yes, my lord.
Ah.
My lord, I request my lordship to take item number 70.
ಆಲ್ ರೈಟ್, ಅದೇ ಕೊಡಿ.
That is Niti Trust versus the state of Karnataka.
See, what do you want to do?
My lord, we wanted to conduct a peaceful protest. My lord, the
Protest
permission.
against what?
My lord, protest seeking a special investigation
Into what?
into Soujanya's murder.
That matter is still pending, is it?
My lord,
Allah, what has happened to the case now?
my lord, as regards my lord,
Trial is pending?
no, my lord, the trial
Then
is
what
not.
then what has happened?
No, my lord, what had happened was the state arrayed one of the a person as an accused,
Ah.
which my lord, this honorable court acquitted on the
Ah.
ground that the person he was falsely framed. That was the observation of this court.
All right.
After that, my lord, a CBI investigation was also conducted.
What happened to that?
My lord, there they have come up with a conclusion stating that no, because there was a lack of preservation of evidence, there is
All
no
right.
much progress could be made. Now, my
All
lord,
right. Now what do you want to do?
my lord, that does not stop me from conducting
Ah.
a protest seeking
Ah.
a special investigation team.
No. Special investigation in what? In a case that is already acquitted.
My lord,
In
where,
a case that has already been acquitted by a court of law, you want to protest against that?
my lord,
No,
this,
is that the intention of protest?
my lord, my lord,
No.
that being the,
Mr. Velan, you should be clear.
yes,
If
my
you
lord.
are wanting to attack a judgment of this court or whatever competent court of law by
Yes,
way
my
of protest, that cannot be permitted.
My lord, that is not our intention. That is not our
Yes.
intention.
Then what is your intention?
My lord, I take my lordship to the permission grant.
No. Then what is your intention? Tell me. You leave the permission granted. Why do you want to protest? Tell me.
My lord, just because, my lord, here it is a matter of
Sir,
record.
1 minute, Velan.
Yes, my lord.
If a matter is pending, if a
Yes, ma'am.
trial is pending, if the
Yes, ma'am.
investigation is shoddy, if
Yes,
the
ma'am.
investigation is not correct,
Yes, my lord.
before the conclusion of the trial, you ought to have raised a protest or whatever it is.
Yes, my lord.
Now, it is not what is this empowering team, hope and interaction? Who is this? Who
My
is the
lord,
petitioner?
My lord, if I may answer my lordship's first question.
Ah,
My lord, merely because a shoddy investigation has reached a logical conclusion before this court, that does
Yes.
not prevent us to protest seeking a formation of an SIT or a commission of inquiry.
when to reopen the whole thing, is it?
Yes, my lord.
Okay, yes.
My lord, that does not, the mere conclusion here does not stop my right. My lord, now the police, my lord, as regards the scope and ambit.
Where do you want to protest?
My lord, I take.
Where do you want to protest, sir?
My lord, 1 second.
Kadapa.
Kadapa, my lord.
Where?
Kadapa, Beltangadi Taluk.
ಎಲ್ಲಿದೆ ಅದು?
Beltangadi
Page
Taluk.
number
I'm
20.
Dakshin Kannada.
ಬೆಳ್ತಂಗಡಿ ತಾಲೂಕು.
Page 32, your lordship may kindly see.
Ah.
Kadapa is the endorsement issued by the police, and page 28 is the initial permission letter. My lord, then an objection comes to be filed by an advocate representing the whole thing. There is a slanderous campaign against the Dharmasthala and its officers, my lord.
Why Dharmasthala is involved in this?
This is
There's no
what
way-
is
there's no
happening.
way.
That is why this is what is happening. There are serious petitions that were moved. In fact,
Why
there was-
Dharmasthala is involved in this?
Allah, the officials,
Huh?
the Dharmadhikari, they are making allegations against the Dharmadhikari and other people.
He was the accused, is it?
He is not there.
Then?
My lord, in fact, my lord,
No, I'm only wanting to know something behind the smoke screen.
no, my lord. My lord, in fact, my lord, the only contention of the respondent is the
Ah.
order of a coordinate bench of this court estoppels us from essentially undertaking any protest. My lord, that is a misreading.
Order of the coordinate bench has become final?
Yes.
Yes, my lord. My lord, in fact, that is a misreading of the judgment. I take my lordship to page 46 for a moment, my lord.
Ah.
The relevant paragraph is 11. May I, my lord?
Yes, sir.
Having regard to the facts and statements narrated herein above, this court is of a considered opinion that the petitioner herein have a right to seek such directions to the respondent police. The respondent police are required to take action in accordance with law if they find that the ninth respondent or his followers or any person makes any statement in open public or publishes any derogatory statement. I lay an emphasis here, my lord. Any derogatory statement which is an offense in accordance with law. And in that regard, if any material is placed by the petitioner or any person aggrieved of any such action on part of the ninth respondent or his followers, and if such information is placed before the police, it is bounden duty of the respondent police to take action immediately. My lord, I have no quarrel with this direction.
All right.
My lord, it states derogatory statement. My lord, there is the word derogatory does not find any mention in BNS. My lord, I will not deal with a subset of derogatory statement. I would say any statement made. Why only derogatory statement, my lord? If any statement is made my lord, which is an offense in accordance with law, the police is at liberty to take action. But what the police, by referring to this particular provision, is doing is acting as an arbiter to adjudicate whether the statement is defamatory in nature or not. That the police is not entitled to. And then they make this observation a basis of essentially issuing a gag order, saying the fact that nobody shall protest.
No, gag order we will not permit, but you will be bound by the coordinate bench's direction. If there is
Yes, my lord.
anything, any violation, coordinate benches, in terms of the coordinate bench's direction, they will take action.
Yes, my lord. Here, my lord, I
But
take.
I'm really asking, what are you going to achieve by this?
Exactly.
If there is any collateral purpose, it's all right, we will not permit you to achieve. But if there
Yes,
any,
my lord.
but if there is any lateral purpose in genuine purpose in seeking something, then you should come out with that.
Yes, my lord. Here, my lord, my lord, I cannot step into the shoes of the potential speakers. I cannot preempt
No,
what they are going to.
I'm not, Velan, I'm not asking that.
Yes,
I'm
my
only
lord.
asking, in a case that is completely concluded and everything is over,
Yes, my lord.
are you asking the exhumation of the entire thing now?
My lord, if I answer my lordship in the
No,
in the
that
entirety,
you should have challenged the order of, somebody should have challenged the order of acquittal.
my lord, the challenging of an order of an acquittal is qua a particular accused. My lord, that does not answer the shoddy investigation per se. My lord, it is the observation of this court that that particular person was framed. My lord, it does not estoppel me, even if there is a lapse of time, my lord, to seek
it's
an
all right.
investigation
Now,
or an exhumation.
All right, Velan, 1 minute.
One submission.
Yes, Jafar.
Page, order of the coordinate.
Justice
bench.
Devdas.
Okay.
Huh.
Adರಲ್ಲಿ in page 10 of the judgment, that is 43. Running page 43, in page 10 of the judgment. There, the first paragraph itself, your lordship can read. The justice for Saujanya was found.
Correct.
Adರಲ್ಲಿ, this is where they have made the allegations against the
All
family.
right. I will straight away follow the order of Justice
Yes,
Devdas, permit them. But if there is any violation as observed by Justice Devdas, you will take action. That is, he will agree that he has no choice about it. Yes, Velan?
Yes, my lord. My lord, the
Learned counsel appeared.
Huh.
The other day on YouTube also.
What
that
YouTube?
The YouTuber whom the
Uh-huh.
Lord state the notice issued at Ballari. There are several people who are now, after entire trial has been completed, and there is a judicial order. In fact, they have gone, the 9th respondent, the order of the coordinate bench, Justice Devdas of the order, had even made allegations against the judges of this honorable court. But there was a
My lord.
contempt which came up before the chief. There he apologized, and they also gave an undertaking. that they will not-
You are the advocate, Velan?
no, my lord, I have nothing to do with respondent number 9.
I don't think he would do all that. Yes.
But anyway, my lord, we'll have to follow this.
My lord, here, may I make a submission, my lord? The
Yes.
facts of the case is relevant here, my lord. There was the respondent number 9 suffered an order in the competent civil court which was instituted by the petitioner. He did not follow the said order. A contempt petition happened to be registered before the division bench of this court. It is in that backdrop this particular order was passed. My lord, in fact, my lord, I have checked multiple times all the provisions of BNS. The word derogatory statement does not find place in any of those provisions. My lord, the only provision which remotely deals with such circumstance is section 299 of the BNS. If my statement falls within that ambit, the police is at liberty to take action. They don't need to resort to this judgment. My lord, what they are essentially trying to do is they're trying to be an arbiter.
No, this gag order, we will not permit to be sustained. I will pass an order following the order of Justice Devdas and permit the respondents to take action strictly in consonance with,
Permission was accorded. Permission was
you
accorded.
have withdrawn that permission later.
An objection.
Whatever,
They may be a party
see,
before this court.
what protest, peaceful protest or whatever, or for whatever reason, then you cannot stop them by gag order saying nobody should protest. But their protest should be in consonance and observation of the order of Justice Devdas, saying that if there is any violation, you will take action. That's all. Ashte Velan, that's all.
Yes, my lord, only one an additional direction my lordship may consider passing. My lord, what constitutes derogatory statement? That is where all the mischief is sought to be conducted here. There is
No.
nothing called as derogatory statement in the BNS.
The order does not stop at derogatory. It says defamatory also.
No, my lord, it doesn't. Please take, my lord. Please
See,
take paragraph
it is
47.
submitted, 9th respondent cannot claim to have absolute right of speech, therefore go before the public, go on making derogatory remarks against the private individuals. Say, submitted, there is defamatory also, I saw somewhere.
Yes.
My lord, that is in the backdrop of a defamation suit preferred by the petitioner. There is no suit preferred against me, or for that matter, anybody who wants to.
Anyway, I'll tell you,
My lord, after that order was passed.
if in the wake of achieving the object, if you are wanting to achieve collateral things by making statements on persons, that cannot be. You want to
Lord,
achieve your objective, achieve it.
My Lord, due process has to be followed. I take my Lordship to page
Both
69 for a
by
moment.
you and them, sir.
My Lord, page
Due
69 for a
process,
moment.
due process is not only for the state, even for the protesters.
Yes, my Lord. Page 69 for a moment, my Lord. Page
Yes,
69
sir.
for a moment.
Yes.
My Lord, here the division bench
So
of
I
this
thought
court,
the trial is pending still. Yes.
page 69, my Lord.
Hmm.
Paragraph 14. My Lord, this was in the backdrop of a TI which was granted. Article 19(1)(a) of the Constitution gives freedom of speech and expression to every citizen.
Absolutely no problem with
Well, let's
reasonable restrictions.
Paragraph 15 and 16, my Lord, for a moment.
Yes, sir.
The learned trial judge, by the impugned order, has restrained the defendants from making defamatory statements against the plaintiff. What is defamatory can be tested and decided only if an act of making a statement or telecasting a program is challenged by the aggrieved person before an appropriate forum. Therefore, in our view, the defendants are not prevented from publishing or telecasting any news.
Which is this, Velan?
My Lord,
Which order is this?
This is against the division bench judgment.
Division bench judgment.
division bench decision of this court, my Lord, which is the Tejasvi Surya's at page 53, my Lord. It starts at page 53. Here, my Lord, a TI was granted by the trial court stating that no defamatory statement shall be made. That happened to be challenged. My Lord, here this is what the honorable division bench of this court held. Therefore, in our review, defendants are not prevented from publicizing or telecasting any news item which is not defamatory in their opinion. That is in our opinion.
See, I will only observe that you can definitely peacefully protest, not violate the law, nor the law as laid down by the coordinate bench or the division bench in any of these cases. Correct?
Yes, my Lord. Yes, my Lord. My Lord, if I may request my Lordship, in furtherance of the same, my Lord, the police may also not act as an arbiter with regard to a defamatory statement. As regards to any other statement, it is fine, my
Now
Lord.
that the observation of the division bench will take, make that good.
Yes, my Lord.
That will take care of that situation. Paragraph 15.
Yes, my Lord.
What the division bench has said, that will only when, if it has to be tested, what is it said? Tested and decided only if an act of that statement is done. Yes.
Yes, my Lord. So, my Lord, the mischief is caused only because they interpret the term derogatory statement as being vesting the power with them to essentially act as an arbiter with regard to any statement made, whether it is defamatory or not. That is where the problem is.
The mischief is not caused by the state, my lord. What has happened is subsequent to the order of Justice Devdas, my lord. What had happened was the ninth respondent has refrained. In fact, the ninth respondent has also come before this honorable court, where where a petition came to be filed to get an order against all those publications in various newspapers, wherein he pulled down his YouTube channel also. He gave an undertaking with this very own court, my lord.
Ninth respondent, which ninth respondent?
He is the one who had started the Justice for Soujanya movement and where he is targeting one family and the authority, that is the Dharmadhikari of Dharmasthala, my lord. Now, what happened after this order of Justice Devdas was passed? Now, what has happened is they are trying to shoot to different forums. Well, they are nowhere corrected, but whatever it is their right to protest. I cannot come in that way.
Yes, my Lord.
Are these trust or whatever trying to achieve something that could not be achieved directly?
No, my Lord. My Lord, we have nothing to do with
Because
respondent 9.
You again state what same thing you are saying about this Dharmasthala and other
Justice
things.
for Soujanya.
My Lord, as regards respondent number 9, my Lord, there were specific statements which was made, which were not in accordance with law. That was what the finding of the learned trial court as well as the division bench of this court. I have nothing to do with them. My Lord, if my statement is in the teeth of any law, they can take action in accordance with law. I have no quarrel with the same. My Lord,
Yes,
if any...
See, 1 minute, Velan. Jafar, we cannot foresee or you cannot foresee what they will speak.
Yes, yes.
And he is also not saying that something they will speak or not speak.
Even
If spoken,
yes,
then action you can take in accordance with the judgments laid down.
Not only this matter, now he has filed an application only to protest. He has not even said what is the subject.
That is why he will file a fresh application.
Yes.
You will consider it in accordance with law
Yes.
and not preempt it. But if they make some statements which are contrary to what the coordinate bench or the division bench has held, you should take action.
Take action.
That is all. Yes, Velan, that should suffice, I guess.
Yes, my Lord. In fact, my Lord, my application is at page 25.
What application have you given there?
My Lord, my application is at
Annexure. What is Annexure A?
my Lord, Annexure A is the trust deed. Annexure B is the application, my Lord. Seeking police permission at page 25.
20?
5.
Yeah, nothing is here.
My Lord.
ಸೌಜನ್ಯ ಕೊಲೆ ಪ್ರಕಾರ ನ್ಯಾಯಕ್ಕಾಗಿ ಆಗ್ರಹಿಸಲು ಆರೋಪ ಇದೆ ಹಾ
ಅದನ್ನ ಹೇಳ್ತಾರೆ. ದಕ್ಷಿಣ ಕನ್ನಡ ಜಿಲ್ಲೆ ಬೆಳತಂಗಡಿ ಪೊಲೀಸ್ ಠಾಣೆ ಮೊಕದ್ದಮೆ ಸಂಖ್ಯೆ 250/12 ಪ್ರಕರಣದ ಕುರಿತು
ಹ್ಮ್.
ಕೋರ್ಟ್ ನಿರ್ದೇಶನದಂತೆ ಧರ್ಮಸ್ಥಳ ಗ್ರಾಮದ ಸೌಜನ್ಯ ಅತ್ಯಾಚಾರ ಕೊಲೆ ಪ್ರಕರಣ ಸಂಬಂಧ
ಹ್ಮ್.
ಅಕ್ವಿಟಲ್
Acquittal.
ಕಮಿಟಿ ರಚನೆ ಮಾಡಿ
ಹ್ಮ್.
ತಟಸ್ಥ ಅಧಿಕಾರಿಗಳ ವಿರುದ್ಧ ಸೂಕ್ತ ಕ್ರಮ ಹಾಗೂ ಈ ಪ್ರಕರಣ ಎಸ್ಐಟಿ ತನಿಖೆಗೆ ಆಗ್ರಹಿಸಿ ಬೃಹತ್ ಪ್ರತಿಭಟನೆ ಮೆರವಣಿಗೆ ಅನುಮತಿ ಕೋರಿ. Where a matter has been concluded, they are very clearly saying that they want, if that is, they'll have to follow a process of law. Let them go before an appropriate court, get an order of setting up.
So they are not, they are general public. They cannot do that.
Even the relatives or the victim itself, they have not, they have.
No, that doesn't stop, your state should not stop protest even.
Not
If it is
stop.
peaceful in accordance with law or whatever it is. Now he has given this application, you had granted permission. Because there is an objection, you withdrew permission. Now let the permission prevail. And you will take action in accordance with the judgments rendered by the coordinate bench or the division bench. In the event they would breach whatever is observed by the court.
Possession will not be allowed. They
What?
want to have possession and everything.
Allah, that is, you will take action in accordance with law. You permit in accordance with law, but you can't stop them from peaceful protest.
We will not stop them from peaceful.
That's all.
Let them not make derogatory statements.
No,
against-
they will, the order of the coordinate bench is there. In accordance with law, whatever action you have to take, please take. In accordance with law, whatever they can do, they are doing. That's
Yes.
all. And
Lord, in fact-
in accordance with law, I will pass some out. Yes.
My lord, in fact, my lord, I have annexed as one of the judgments of a coordinate bench of Annexure F.
Justice
Where-
Hemant Chandan Gaudra.
Yes, my lord. In
All
fact, a defamate, a complaint was preferred through a power of attorney holder. The same was quashed, stating the fact that he
All
is
right.
not an authorized
Well-
person.
We'll close this. Both matters 69, 70 ಎರಡು ಒಂದೇನಾ?
ಅದರಲ್ಲಿ 69 ಅಲ್ಲಿ they want permission in Bangalore. Freedom Park.
ಅಲ್ಲ, wherever Freedom Park. Why?
That is what is happening
No,
now.
where, see, protest, you play designated place if it is permissible in law also. Everything you should consider in accordance with law, that's all. Both these petitions are preferred by different petitioners for the same cause of action, for holding a peaceful protest. For the sake of convenience, the facts obtaining in writ petition 7957 of 2025 is noticed. Heard the learned counsel, you are A. Velan, right?
Yes, my lord.
A. Velan appearing for the petitioner along with Barthkode Israel. So and so in both these cases. The issue in the list lies in a narrow compass at this juncture. The petitioners claim to be petitioner trust. ನೀವೇನ್ ಮಾಡ್ತೀರಾ ಅಂತ ಹೇಳಿಲ್ಲ, ಯಾವತ್ತಾಗಿರೋದು? Petitioner trust registered in the year 2015 is set to now taken up the cause of justice for one Saujanya. In furtherance thereof, for a conduct of a peaceful protest on 11/3/2025, and the demand for an acquittal review committee and to take action against the police officers involved in the investigation and seek reinvestigation, seek permission from the hands of the jurisdictional police to hold such protest. The representation to the jurisdictional police, ಯಾವುದಿದು ಬೆಳ್ತಂಗಡಿ, ಕಡಬ ತಾಲೂಕ್
Police.
ದಕ್ಷಿಣ ಕನ್ನಡ reads as follows. Page 25, Annexure B, seal number 70 ಅಲ್ಲಿ madam. So the representation is clear that it is protest against the acquittal or seeking an acquittal review committee for the death of one Saujanya. ಯಾವಾಗ ಆಗಿದ್ದು ಇದು? 2012. Death in 2012. The the deputy commissioner, the Tahsildar of Kadaba Taluk grants permission to hold the protest in terms of his in terms of his order dated 14/3/2025. After the grant of permission, it transpires that objection is filed by an advocate. And basing upon the said objection, the permission so granted is withdrawn on the next day by issuance of an endorsement on 15/3/2025. It is this action of withdrawal of the endorsement that has driven the petitioner to this court in the subject petition. The learned counsel A. Velan submits that the right to protest peacefully or right to protest as the case would be cannot be stalled by the state by issuing orders, by issuing gag orders. The gag order in the case at hand is that the state issues an order that nobody should protest on the issue. Therefore, the learned counsel submits such orders cannot be countenanced in law. He would further contend that the permission is withdrawn on twin score. One, objections by the advocate, and the other, the order passed by the coordinate bench in writ petition 19382 of 2023. The learned counsel would seek to distinguish both the cases, distinguish the judgment rendered by the coordinate bench, contending that it would not become applicable to the facts obtaining in the case at hand. He would further contend the protest would be peaceful, and if there is any violation of law, the police are at liberty to take action in accordance with law. The learned counsel for the learned AGA, Muhammad Jafar, would also submit that if the protesters would violate the directions issued by the coordinate bench in 19382 of 2023, they should be reserved liberty to take action in accordance with law. Therefore, the issue is the permitting the petitioners to protest on an issue that they are wanting to project in terms of the representation. The representation is quoted herein above. Permission was granted, it is withdrawn, owing to the fact that owing to the twin fact as observed herein above. Therefore, it becomes necessary to notice the judgment rendered by the coordinate bench in writ petition 19382 of 2023. The coordinate bench has held as follows. Full order applicable. Though the learned counsel for the petitioner would seek to distinguish the said judgment to contend that it is inapplicable to the facts of the case, since both these issues relate to one solitary fact of justice for Saujanya, I deem it appropriate to paraphrase the findings therein to the subject order. As also the judgment rendered by the division bench in WP 15399 of 2019. The division bench in the aforesaid judgment holds as follows. Para 5 to the end. The division bench was considering an identical gag order issued by the state against the protesters. The division bench observes that what is defamatory or what could be defamatory can be found only when the protesters are when the citizen is permitted to protest, as every citizen has freedom of speech and expression as obtaining an Article 19(1)(a) of the Constitution. In that light, following the orders passed by the coordinate bench as also the division bench as quoted supra, I deem it appropriate to permit the petitioners to hold a peaceful protest strictly in consonance with law. And if there is any violation of the observations made in the aforequoted judgment of the coordinate bench, it would be open or it shall be open to the respondent state to take action in accordance with law, which is also observed by the coordinate bench. With the aforesaid observations, the petition stands disposed.
My lord, if I may seek the indulgence of my lordship, if my lordship could make one statement, that the respondent police is specifically estoppel from arbitrating whether the speech is defamatory or not.
ಅದು ಮಾಡಿದಾಗ ಹೇಳಿ. ನೀವು ಹೆಂಗೆ ಸ್ಪೀಚ್ ಮಾಡಿದ್ಮೇಲೆ ಡೆಫಾಮೇಟರಿ ಆಗುತ್ತೆ, ಅವ್ರು ಮಾಡಿದ್ಮೇಲೆ ಹೇಳಿ.
Oblige.
Both disposed. ಎರಡು ಒಂದೇ ಅಲ್ವಾ?